Hello, this is Captain Chaudhary. Our today's topic is Merchant Shipping Act. India, as you know, is a large maritime country with a massive coastline. Just after the independence, we did not have any firm regulatory means to conduct our maritime affairs. Legal tool was necessary to conduct the activities, to create infrastructure for running the shipping. Like India's maritime was just about budding. We needed an act, we needed a regulatory body. So you talk about the international, you talk about the coastal, you talk about regulatory. A lot of areas were, void. So Merchant Shipping Act was enacted in Parliament in 1958. An Indian instrument was needed, an Indian legislative body was needed so that we could register the ship as Indian ship. Typically, it is said that the purpose of the Act is to foster the development and ensure the efficient maintenance of mercantile marine in a manner that would best suit to serve the Indian interests. So, as I said, Merchant Shipping Act provides for registration of Indian ships. It provides a definition of what is Indian, who can be the owner of Indian ship. An individual should be citizen of India, or if it is a company, then the company has to be enacted under the Companies Act. It may be a company under the Cooperative Society Act. It's a company whose major place of work is in India. What happens if we purchase a second-hand vessel? What happens if we procure a vessel in foreign country? What is the role of consular officer? There is a very big part or chapter which deals with seamen and apprentices. So there are various aspects in respect of the seamen, for example, engagement, discharge. A seaman that is distressed, various aspects are considered. Except for the vessels which are less than, say, 15 GRT, exclusively coasting on Indian coast, every other vessel has to register as Indian vessel if it is an Indian ship. The ship other than 200 GRT exclusively on Indian coast has to have an agreement of master with crew and should have an official logbook. There is a part on investigation and inquiry. Inquiry means a preliminary inquiry which is done by government surveyor, and formal investigation means investigation by the court. The moment you say formal investigation, formal means something which is not departmental, which is conducted by the court. There is a provision for having a license to trade from the DG shipping, as well as a license for the coasting trade, which the ships which are engaged in coasting must procure from DG shipping. Then there is a section in respect of safety. This is the section which deals with various aspects of safety. For example, the construction of the ship, the load lines, the areas like collision regulations. It also deals with several other aspects like LSA and FFA of the ship. There is a part that deals with the preventive measures which should be taken so that the pollution does not take place. So as I said, the objective of Merchant Shipping Act was to foster the development and to ensure the efficient maintenance of mercantile marine. What is done to achieve these objectives? So this is achieved by establishing National Shipping Board, MMD, DG Shipping, and various port offices with the principal officers, surveyor in charge, etc. Then various other offices which are connected with the maritime activities, say for example Seamen's Club and Seamen Employment Offices, etc. It's also done by providing registration facilities for the ship and providing for certification, safety and security of the ships. It is also done generally by amending and consolidating the law in respect of merchant shipping. Part 1 is preliminary, which gives a short title, and in addition to that there is preliminaries and various definitions are given in this part. Part 2 or chapter 2 is in respect of provisions about formation, establishment and functions of National Shipping Board. Part 3 deals with general administration. So there is a provision for MMD, DG shipping. So it deals with the appointment of principal officers at major ports, for example Mumbai, Calcutta, Chennai. It also deals with the appointment of many other officers apart from principal officers and surveyors, say for example radio license inspectors, naval architects and Seamen's development officers. Part 4 deals with Shipping Development Fund. This is abolished by an Amendment Act of 1986. Part 5, as I told you, deals with registration of the vessel. There is a procedure which has to be followed in case a ship has to be registered as Indian flag vessel. It also deals with carving note and providing information in respect of the number that has to be put up in the conspicuous part of the ship, typically the beam of the vessel, the main beam of the vessel. Part 6 deals with certificate of officers. It also deals with safe manning. That is the responsibility of administration. Part 7, as I told you before, it's a long part, one of the longest ones with so many sections. It deals with seamen and apprentices, various aspects, engagement, discharge, what happens if a person is distressed in a foreign country, what happens if seaman dies, what happens if he deserts the ship. So various provision in respect of penalties or disciplinary actions which can be taken against the seaman. What happens if the seaman wants to go to the court? How you do the log entry of a seaman? Who all must sign? What is the provision if a seaman wants to go to the court, and what is the importance of log entry in that respect? What happens if a seaman is convicted? What happens if you put a penalty? Part 8 deals with the pilgrim ships or STP, standard trade passenger vessels. The concept of standard trade passenger applies to area which is in Indian Ocean and Pacific. Starting from the Red Sea downwards, you come to Madagascar. From there you go east up to, say, Australia, and then you come up to the Far East and come back to the Red Sea. So this is the area which is, you may say, relatively protected, whereby in 1971 in London they made an agreement which is called STP agreement, that the countries in this region, they can depart from the provisions of chapter 2 and 3 from SOLAS that time, and they can create their own rules in respect of these ships which carry large number of passengers on deck, etc., unberthed passengers. These passenger ships, they are employed on certain routes, certain trades, and depending on the duration of the voyage and number of passengers you have on board, you have various subdivision lines. Part 9 is safety. This part is a very important part, as I said before. It has provision in respect of rules covering LSA, FFA, the rules in respect of construction of the vessel, rules in respect of collision. It also deals with stability aspect, what information to be provided to a ship's master. Typically it is said that the master should be provided with such information that in any service condition that would include probably in today's time the flooded condition also, or the bilge condition also, or any service condition, fully loaded, partly loaded, the master should be able to make an accurate assessment of the ship's stability by rapid and simple means. You could be provided with the tables or drawings, etc. So load line, timber, dangerous goods, grain, etc. are the other things which are covered. So this part also deals with various safety certificates. Say for example, safety radio certificate, safety equipment certificate, exemption certificates. Whenever in Merchant Shipping Act anything is suffixed by capital A, capital B, etc., whether it is section or it is name of the part, it means it has come, it was not originally there, it has come after an amendment. Part 9A deals with nuclear ships. Part 9B deals with security of the ships and port facilities. Part 10 deals with collision accidents, and it is influenced by the Collision Convention. Collision Convention means, basically it is not called REX. Collision Convention means the responsibility which should be entrusted on different ships in collision. What is the proportion of liability? And what should be done after collision? What is the duty of master after the collision? So these are the things which are dealt in Collision Convention, and the things are reflected here in Chapter 10 of Merchant Shipping Act. Part 10A deals with limitation of liability of ship owners in respect of certain claims. Part 10B deals with provision of civil liability in respect of oil pollution. Part 10C deals with IOPC, that is International Oil Pollution Compensation Fund. Part 11 deals with navigation. It puts a duty on master to report the dangers, for example, ice, derelict, gale forces, the storm, etc. And at the same time, the duty of master to proceed towards a ship that has given out distress message with all the speed, unless there are reasons for not going, unless it is not required to go there. The reasons as well as the details in respect of this distress call should be entered in the official logbook. Part 11A deals with prevention and containment of pollution of the sea by oil. It gives powers to central government in respect of prohibition of oil pollution or oily mixture discharge in the water and maintenance of an oil record book. Part 11B is anti-fouling systems. Part 12 deals with investigation and inquiry in respect of a marine casualty or an incident. Surveyor can go on board for preliminary inquiry. It gives powers to the court to conduct the formal investigation. There is a provision for marine board which can be created by a consular officer in foreign countries. There is a provision whereby the master, chief engineer, or the officers on board can be removed after the conduct of inquiry if they are found guilty. In addition to all this, the constitution of Court of Survey is provided for in this part. Part 13 deals with wreck and salvage. There is a provision for the salvage regulations which have to be followed by Indian flag vessel. There is a provision like what happens if the commander of an Indian Navy goes for salvage. Does he get salvage or not? There is also a provision for a receiver of wreck who has got the administrative powers which are different than what the master has. Master has overall power in respect of coordination of the things on the ship, but receiver is the one who will guide the master as well as have connections with the shore authorities like policing authorities in respect of various situations which may be created after a wreck is formed close to the coast. Part 14 is powers of central government in respect of Indian flag vessels or any vessel that is engaged in coasting trade of India. Part 15 is provisions in respect of sailing vessels, and 15A is registration of the fishing boats. Part 16 has got provision for penalties for violating the provisions of the Merchant Shipping Act. Part 17 is miscellaneous provisions in respect of appointing the examiners, the powers of surveyors to board the vessel and do the inquiry in respect of death, etc. Part 18 is repeals and savings. Now we talk about the amendments, the important amendments which were done to the Merchant Shipping Act 1958. Initially, when the Merchant Shipping Act was created, it had a limited profile, it had limited subjects. But as and when the shipping grew internationally also, there were different conventions which came in. So India must show their compliance with the various international conventions. So from time to time, amendments had to be done so that we show our compliance to the international regulations and we advance together with the international shipping. So Amendment Act 1966 was to incorporate the provisions of safety of life at sea, SOLAS, of that time into our system. And from then on, time to time, the rules in respect of the areas which are covered by SOLAS were created in India, and various provisions of SOLAS as amended from time to time were incorporated in our system-wide the amendment. So we are party therefore to the SOLAS Convention. As per Amendment Act of 1970, Part 10A was included in our Merchant Shipping Act, whereby India became party to the convention, that is limitation of liability for certain claims. As I told you, this was pre-1976. So limitation of liability for maritime claims 1976, we are party to that convention, but at this moment the amendment of 1970 was in respect of limitation of liability for certain claims which existed before LLMC 1976. The Amendment Act of 1979 gave a provision whereby Indian officers were obliged to serve on Indian ship or government ships. The 1983 Amendment Act had provisions for International Convention on Prevention of Pollution of Sea in accordance with the amendment of 1954 Oil Pollution Act. The Amendment Act of 1986 caused Section 80 of Merchant Shipping Act being deleted, which had a provision of providing certificate of service to the naval officers, and they could become the captains of merchant ships. But this was against the STCW principles, whereby any person who's serving on the ship should have the training, certification, etc. as per the STCW. 1986 Amendment Act to abolish Shipping Development Fund was incorporated, and the responsibilities were delegated to Shipping Credit and Investment Company of India, a company that is registered under Companies Act 1966. 1988 Amendment Act incorporated the provisions of Civil Liability 1969 and its protocol 1976 into our system. Part 10B was included. Amendment Act 1991 had provision for a review committee under the chairmanship of DG Shipping, so that the Merchant Shipping Act looks new, fresh, amended, modified, and in line with the activities of international shipping. Amendment Act of 1998 had provision for a foreign seafarer who's in Indian territorial water to make complaint and his complaint be heard in India. Amendment Act of 2002 included a new section 76, which is in respect of the certificate of competency to be held by Indian officers. 352A to 352R were the sections included in respect of limitation of liability of ship owners in respect of certain claims. Part 10C named International Oil Compensation Fund was included, and there were sections from 352S through 352ZA included in the Merchant Shipping Act. Amendment Act 2003 caused the inclusion of section 356A to 356H. These were in respect of the issuance of preventive measures of pollution certificate to a foreign vessel or Indian ships in foreign country. Amendment Act 2007 caused inclusion of section 99A, which is in respect of prohibition of engagement of any seafarer without seaman's identity document. Part 9B, that is the security of ships and port facilities, was included in the Merchant Shipping Act. Amendment Act 2014 caused inclusion of Part 11B, which is in respect of control of harmful anti-fouling systems. The Second Amendment Act of 2014 incorporated MLC 2006 into Merchant Shipping Act. The changes are generally made to Part 7, including Section 88A, new definitions, 88B, application of maritime labor standards to seafarers and ships, 138A, working hours of seamen, 176A, ships to possess maritime labor certificate and declaration of maritime labor compliance, 177A, power to make rules to prevent accidents, etc., special provisions for the protection of seamen in respect of litigation, 218A, power to make rules for the purpose of Maritime Labor Convention. Some amendments were effected in 2016, which were caused due to amendment to Finance Act 2016, the 15th schedule. These affected the section 261 and 262 in respect of special trade passenger ships, section 356M, 356N, 356O from the part dealing with prevention and containment of pollution of the sea by oil.